Okay, we're on chapter 8 now. Um, this chapter has 10 questions, so we'll move through chapter 8, and then we may combine a couple of chapters next. There's not quite as many questions on that. Question 1 in chapter 8, courts have the power to review a case for errors of law or courts of appellate jurisdiction. So anytime you think of appeal or you think of appellate, they're reviewing a past decision. So that one's appellate. Federal district courts are courts of original jurisdiction. So original jurisdiction means it's the first time a case has been tried and it's brought before a district court. Question 3, there are currently 94 U.S. district courts. Question 4, which of the following is a factor that determines the jurisdiction of federal district courts? And that's the subject matter of the case. So you've got family law, you've got criminal law, and you've got different types of subject matter, and that determines the jurisdiction of federal district courts. Question 5. The Circuit Court of Appeals were created by Congress in 1891 as a way to reduce the case burden of the U.S. Supreme Court. So many times the Circuit Court of Appeals, a case is stopped there and it won't make it on to the U.S. Supreme Court. So it lightens the burden on that, and that's what it was created for. Question 6. There are currently 13 U.S. Circuit Courts of Appeals. There's 13 U.S. Circuit Courts of Appeals. How many justices sit on the U.S. Supreme Court? And those are, it's 9. 9 Supreme Court justices. Question 8, which of the following state courts has authority to try all cases, both criminal and civil? And that's going to be trial courts of general jurisdiction. If you try to remember that, just think of general as encompassing everything, and you can think of both criminal and civil. So the correct answer is trial courts of general jurisdiction. Question 9, identify a true statement about a court-appointed lawyer. And the correct answer is most are paid by the jurisdiction. And when you think of jurisdiction there, you're thinking of the court. So most are paid by the court. One of the potential answers there was, and you would think that it could potentially be right too, the frequently represent indigent clients pro bono, but actually it's not pro bono because they are being paid through the jurisdiction, so they're being paid to represent the client. It's just not being paid by the client. Question 10, the last question. The most frequent reason given by prosecutors for not prosecuting cases is, and this is definitely true, insufficient evidence. Most of the times that a prosecutor won't prosecute is simply because there's not enough evidence to get a conviction. Okay, that's chapter 8. Thank you.